Well, folks, it looks like there was a brief that was filed in on time to meet the SJC brief deadline, but it wasn't by the Commonwealth, folks. No, it was by the ACLU backing Karen Reed's double jeopardy claims, calling the mistrial declaration by our favorite judge, the Honorable Beverly Cajones, hasty. Well, the last time we heard about the ACLU getting involved in a MSP-related matter was none other than when they declared to the media, calling in for the feds to step in and take over the investigation of Enrique Delgado Garcia, the MSP recruit that was brutally unalived during a, quote, training exercise. Now, it has been over a month since Enrique's death. The MSP 90th RTT class has graduated in style. You can check out the video that I did covering that. But before we get too excited about this, I have a message to share from our favorite attorney, and I don't even want to call him a YouTube attorney because he doesn't have his own channel yet, but I'm sure he will when he decides to eventually retire. He's got the fan base for it, folks. Our favorite panel guest attorney, Mark Betterow, says, buzzkill warning, amicus briefs, and this is what this one exactly is that we're going to go through to today, are very common in appellate practice, including those from the ACLU. Better to have them for you than against you, but I would not assume a favorable ruling is more likely merely because one has been filed in support. And I'm glad that he clarified things up before I recorded this video because I, like many of you guys, I'm not a lawyer, as I say in the beginning of every single frickin' video, but I do get excited when I see things like this happen. And I think it's completely ironic in the fact that we haven't seen at least at the time of this recording, the Commonwealth file their own brief. So what on earth does this mean? Well, I can't answer that question for you, but I'm sure there's a lot of very intelligent law tubers who can. What we are going to do together in today's video is go over this ACLU brief filing. So let's get into it. Hello, hello, hello. Welcome to Alexasrewm, where we are not lawyers, we are not medical professionals, we are not law enforcement, we are just people. People who have opinions about all things going on in the true crime community, including this amicus brief that was filed earlier today on behalf of Karen Reed by the ACLU. So the American Civil Liberties Union, aka the ACLU Foundation of Massachusetts, is backing Karen Reed in her appeal to the state's Supreme Judicial Court to protect her from being retried on acquitted charges, according to a filing on Wednesday, aka today. This is all background context that we know. In Wednesday's filing, the Civil Liberties Union says the retrial would violate her constitutional rights, citing the Fifth Amendment, which I believe they also cited in their brief as well. I don't think I did a video on that, but I know a lot of people already have. Which prohibits someone from being tried on the same charge twice, thus violating the double jeopardy clause, right? A retrial on acquitted charges would violate the prohibition against double jeopardy, a critical right enshrined in the Fifth Amendment to the United States Constitution and Massachusetts common law. Now, this is interesting because usually we don't see or hear from the ACLU. In particular cases, at least, I mean, let's keep it a buck, where it involves a infringing on the rights of a seemingly privileged, right? That's how they want to characterize her in the press, right? The seemingly privileged, beautiful white woman. So I think it's really interesting how, twice within the last 60 days, they have spoken up on behalf of something going on in the state of Denmark, or in the state of Massachusetts. The ACLU also called Judge Beverly Cajones's decision to declare a mistrial hasty, as did we all, very well said, and did so without polling jurors to confirm they were deadlocked on all counts, or even asking the parties whether they consented to a mistrial or wanted the jurors polled according to the filing, which again, we've talked a lot about here on this channel, but it goes back to like this whole argument about she didn't ask. Therefore, you can argue there was not consent from either side. So, there you have it. The trial court had a clear path to avoid an erroneous mistrial. Simply ask the jurors to confirm whether a verdict has been reached on any count. Soon after the hasty mistrial declaration, multiple jurors reported that the jury had actually agreed to acquit appellant on counts 1 and 3, and so were only deadlocked on count 2. Count 1 was the second degree, was the M2 count, and then count 3 was leaving the scene of personal injury or death, which would leave Reed only to face one charge of OUI/manslaughter. The SJC, like I said, is scheduled to hear the appeal on November 6th. The full amicus brief is available here, which we are going to get to. So buckle up, kids. Get your favorite beverage. Get your favorite snack. Let's talk some legal mumbo jumbo and try to make sense of it, right? And see, whether or not, again, like Mr. Mark Betterow says, don't get too excited. Corporate disclosure and Rule 17C5 statement. So this is just, again, kind of summing up of, hey, we don't have any stock in this. No party's counsel or any other person or entity other than the ACLU, its members, or its counsel contributed money that was intended, because that the other side is going to be like, now Karen Reed's paying the ACLU? My goodness, this conspiracy is out of control! Contributed money that was intended to fund the preparation or submission of the brief. ACLUM and its counsel do not represent and have not represented one of the parties to present the appeal in another proceeding involving similar issues. They do not represent and have not represented one of the parties, aka Karen Reed, to present the appeal in another proceeding involving similar issues, and were not parties in and did not represent a party in a proceeding or legal transaction that is at issue in the present appeal. Prior to seeking leave to file this brief, ACLUM asked counsel for Ms. Reed, appellant, and the Commonwealth appellee whether they would assent to or oppose ACLUM's motion to file this brief. Appellant's counsel assented, and the Commonwealth took no position. I wonder if they also asked, hey, we're preparing our brief. Where are you guys at, right? Not that obviously they would know, but I'm just saying, I think it's extremely ironic. Interests of amicus curiae. ACLUM is the Massachusetts affiliate of the National American Civil Liberties Union, is dedicated to protecting and advancing the civil rights and liberties of all people in the Commonwealth, yada yada, including those guaranteed by the Constitution Bill of Rights. It frequently engages in litigation and other advocacy to protect the rights of people. So again, just giving background context, I'm going to kind of skip ahead a little bit. Here, we take no position on what the evidence presented at trial did or did not show. Rather, this brief addresses the trial court's decision not to respond to compelling evidence that there was a potential mistake or misunderstanding concerning the outcome of the jury's deliberations and what process will be employed by trial courts addressing any similar circumstances in the future. Introduction and summary of argument. Defendant appellant Karen Reed faces the possibility of being retried on multiple criminal charges for which numerous jurors now claim they acquitted her. A retrial on acquitted charges would violate the prohibition against double jeopardy. They come right out the gate, guys, and just say it how it is. I love it. A critical right enshrined in the Fifth Amendment to the United States Constitution and Massachusetts common law. If the court does not grant the appellant's requested relief to dismiss or otherwise preclude the counts on the current record, then this court can and should prevent the potential for injustice by ordering the trial court to conduct an evidentiary hearing, which is what we have all been saying. And guess what, folks? It happens. It happened in the Ashley Benefield case. It did. The judge called in the jurors and interviewed the juror at question. It happens. It freaking happens. It is not that big of a deal. We can just squash this thing, nip it right in the bud if we just call them in. I don't get it. I don't get what the big freaking deal is, right? And determine, sorry, I'm heated, and determine whether the jury in her first trial agreed to acquit her on any count such that it was not manifestly necessary for the trial court to declare a full mistrial. This brief provides the court with additional context regarding the justifications for an evidentiary hearing into a lack of manifest necessity, which we know back in a bunch of the previous briefs, Adam Lally loves to use the term manifest necessity all throughout, and even in his oral argument as well too in front of the Honorable Beverly Cajones. At appellant's first trial, the court declared a mistrial on all three counts. We're coming for you, Bev, after receiving notes indicating jurors were struggling to reach a unanimous verdict. But the court did so without polling jurors to confirm they were deadlocked on all counts. Again, that also happened in the Ashley Benefield case. Not the same exact situation, but at the end, after they came out with their verdict, and it was a guilty verdict, right? The Judge White asked the attorneys, hey, do you want a jury poll? Prosecution said no. Defense said no. Everybody said no, but you still ask. You still ask. It's not up to the attorneys to ask. That's the judge. She's the ref. She's the one who's keeping everybody okay. You can do this. You can't do this. Yes to this. No to that. That's how it works. That's the point of having a referee in any sports game, right? Is to make sure that everybody is following the rules and everybody is giving a fair chance. Now, one can argue, did that happen in the Karen Reed trial? Well, I'll let you be the judge. But the court did so without polling the juries to confirm they were deadlocked on all counts or even asking the parties whether they consented to a mistrial or wanted the jurors polled. Again, it takes 2 seconds, Bev, and then you can go have as many White Claws as your little heart desires. Soon after that hasty, there's that word, buzzword, mistrial declaration, multiple jurors reported that the jury had actually agreed to acquit appellant on counts 1 and 3, and so were only deadlocked on count 2. Appellant promptly moved the trial court to either dismiss counts 1 and 3 or at minimum conduct a post-verdict evidentiary hearing. We could have done this months ago, y'all, to assess the truth of the jurors' reports. But the trial court denied the motion to dismiss and refused to conduct a hearing, leaving open the possibility of appellant being retried in violation of her right to be free from double jeopardy. The trial court erred in refusing to conduct an evidentiary hearing. The double jeopardy clause protects the defendant's fundamental right against successive prosecutions for the same offense. That right is deeply rooted in our nation's history and legal system and has been vigorously enforced by both the United States Supreme Court and this court. To avoid improper successive prosecutions, The double jeopardy clause requires that courts carefully consider alternatives to declaring a mistrial and to make such a declaration only after finding a mistrial to be a manifest necessity. A failure to do so can bar re-prosecution on double jeopardy grounds. The trial court had a clear path to avoid an erroneous mistrial. Simply ask the jurors to confirm whether a verdict has been reached on any count. And remember, Marty Weinberg summed it up pretty easily. Pretty simply put, he just said, hey, we just need to ask one question, maybe two at most. So asking those questions before declaring a mistrial is permitted, even encouraged by Massachusetts rules. Such polling serves to ensure a jury's views are accurately conveyed to the court, the parties, and the community, and the defendant's related trial rights are secure. It is also consistent with the nationwide practice of polling juries to ascertain verdicts, including before declaration of a mistrial. Here, a post-trial evidentiary hearing would serve the same purposes, enabling the trial court to determine whether the jurors had actually agreed to acquit appellant on counts 1 and or 3, such that it was not manifestly necessary for the court to declare a full mistrial. Accordingly, an evidentiary hearing is required to safeguard appellant's rights under the double jeopardy clause, and court should order the trial court to conduct one. The probation against double jeopardy is a fundamental constitutional right that protects against the burden of multiple prosecutions. The double jeopardy clause of the Fifth Amendment provides that no person shall be subject for the same offense to be twice put in jeopardy of life or limb. U.S. Constitution Amendment 5. At the heart of this policy is a concern that permitting the sovereign freely to subject the citizen to a second trial for the same offense would arm government with a potent instrument of oppression. United States versus Martin Linen Supply Company. So they're quoting some of the similar case law that I believe Karen Reed's team did as well during oral arguments. Thus, the double jeopardy clause exists to ensure that the government, with all its resources and power, and remember, folks, the government has unlimited funding. They can try and try and try and try and try again because they're using what? Taxpayers' money. Your money if you live in Norfolk County, right? Is not allowed to make repeated attempts to convict an individual for an alleged offense, thereby subjecting him to embarrassment, expense, and ordeal, and compelling him to live in a continuing state of anxiety and security. Green versus United States, meaning that you can't just keep retrying them, or you can't keep doing this again and again and again and again, because most people don't have unlimited resources. Eventually, no matter how many times P. Diddy wants to try and get bail, he's eventually, right now he seemingly has unlimited funds. But eventually the well is going to dry. It's going to dry up. But the government, no matter how many trillions of dollars in debt we are, has unlimited funding. No matter what state you're in. Because it's not their money, it's our money. And the people don't want to pay for this. They don't want to re-prosecute Karen Reed. There's a small sector of people who do, but that doesn't make up the majority of the tax-paying collective, and it's disgusting. The historical roots of the double jeopardy clause long predate the American founding. Its origins can be traced to Greek and Roman times. We're getting a history lesson here, folks. The double jeopardy clause, just quick footnote, has incorporated against the states through the 14th Amendment, see Benton versus Maryland. And it became established in the common law of England long before this nation's independence. Benton, see Bartkus versus Illinois. Black J. dissenting, fear and abhorrence There's a word. Of governmental power to try people twice for the same conduct is one of the oldest ideas found in Western civilization. In medieval times, canon law prohibited double jeopardy on the basis that God does not punish twice for the same transgression. J.A. Sigler, A History of Double Jeopardy. And as early as the 15th century, the English courts had begun to use the term jeopardy in connection with the principle against multiple trials, United States versus Wilson, 1975. This thread continued through Sir Edward Coke's 17th century treatise on the laws of, excuse me, I gotta take a sip of water, I'm losing my voice here, of England, which articulated a theory of double jeopardy. See 3 Edward Coke Institutes on the Laws of England. And in his 1769 commentaries, Sir William Blackstone famously wrote of the universal maxim. And in his 1769 commentaries, Sir William Blackstone famously wrote of the universal maxim that no man is to be brought into jeopardy of his life more than once for the same offense. For William Blackstone commentaries. Concerns about double jeopardy crossed the Atlantic with early American colonists. In fact, the American conceptualization of double jeopardy began with the Massachusetts colonies. Let's bring them up, right? We're in Massachusetts, where all of this was frickin' born. Body of Liberties provided for an expansive prohibition against double jeopardy that extended to criminal and civil offenses. See Massachusetts Body of Liberties. This provision was mirrored and extended in the Massachusetts Code of 1648, which required the express recording of past legal actions to prevent future jeopardy. See David S. Rudstein. A brief history of the Fifth Amendment guarantee against double jeopardy. Citation omitted. These foundational tenets of Massachusetts law arguably shaped the nation's subsequent adoption of the double jeopardy clause in the Fifth Amendment. See Sigler. While enactment of the double jeopardy clause was relatively uneventful, see Rudstein, Sigler, Supra at 306. Early American jurists, that's a word, quickly recognized its importance. An 1824 Kentucky Supreme Court's opinion referred to the prohibition on double jeopardy as a wise rule, so favorable and necessary to the liberty of the citizen, Commonwealth versus Olds. An 1833 decision by the New Jersey Supreme Court observed that this great principle forms one of the strong bulwarks. I have never heard that word in my life. That's a fun one. Bulwarks of liberty, State versus Cooper. And in 1834, Justice Joseph Story called the Double Jeopardy Clause a constitutional recognition of that fundamental rule of the common law, which has been recognized by elementary writers and courts of justice from a very early period down to the present times, United States versus Gilbert. See also Joseph Story, yada yada. Listing the Double Jeopardy Clause as a provision enacted to secure the great palladium of liberty, the trial by jury, in criminal cases from all possibility of abuse. In modern times, the Supreme Court has recognized the fundamental import of Double Jeopardy Clause by expanding its scope, notwithstanding the text of the Fifth Amendment. Double jeopardy protection extends to all crimes, capital or otherwise. See Ex parte Lang. And the existence of an acquittal is a question of federal, not state, law, with a constitutional floor that prevents the states from impeding a defendant's double jeopardy rights. See McElrath versus Georgia. Jeopardy also attaches when a jury is impaneled and sworn in, not when a verdict has been given. Finally, as relevant to this case, the double jeopardy clause can bar retrial, even when the first trial ends in a mistrial with no acquittal or conviction. For even if the first trial is not completed, a second prosecution may be grossly unfair and burdensome to the defendant, meaning you can't bleed them dry. They have a right to effective counsel. Arizona versus Washington. Moreover, the defendant has a valued right to have this trial completed by a particular tribunal, Wade versus Hunter, or chosen, that's funny, Wade Hunter, or chosen jury, such that only the showing of manifestness, I guess I meant necessity or manifest necessary, will allow a trial court to declare a mistrial without barring a retrial on double jeopardy grounds. Wade, yada yada. The decision to declare a mistrial without a defendant's consent is only justified by a high degree of necessity and requires a scrupulous, I love that word, exercise of judicial discretion. United States versus Jorn. In Massachusetts, where there is no specific constitutional protection against double jeopardy, but where the common law protection thereof may be greater than either the state or the federal constitution requires, Berry versus Commonwealth. We got some Commonwealth cases here in Massachusetts. A declaration of mistrial requires the trial court to both, 1, provide the defendant's counsel with a full opportunity to be heard, and 2, carefully consider alternatives to a mistrial. See Commonwealth versus Taylor. Again, another citation from a case law cited from one that Weinberg has cited during oral arguments. Together, the above sources sing a simple but powerful melody regarding the importance of the right against double jeopardy in criminal proceedings, which is deeply ingrained in the Anglo-American system of jurisprudence, Green, and bolstered by recent precedent. Accordingly, when the government asserts the power to retry a defendant who has already gone through the burdens of one full trial, as is the case here, courts must safeguard the defendant's fundamental rights by carefully scrutinizing the assertion in light of all available information. All right, so next section. Trial courts regularly poll juries both after a verdict is announced and before a mistrial is declared. Bang, bang, we're coming after you, Beverly Cojones. You better get this last sip of White Claw in. 'Twill be your last one for a long time, Beverly. In her motion to dismiss, appellant asked for a post-verdict evidentiary hearing to determine whether the jury had agreed to acquit her counts 1 and 3. The Commonwealth opposed this request as improper, but it wasn't. The trial court rejected it as prohibited. But the propriety and sometimes necessity of inquiring about the outcome of a jury's deliberations is confirmed by the fact that trial courts regularly poll juries on verdict-related issues. And yes, again, yes, scream it from the rooftops. Yes, it is not that bizarre. It happens. We've seen it happen a lot in recent cases that have been streamed and covered, not only on my channel, but other channels, right? A lot has happened and even unfolded in regard to potential juror misconduct, right? We've seen it time and time again. This is not new news, folks. It's just, it ain't. Massachusetts courts frequently poll juries to determine whether the announced verdict was correct. Exactly. So not only are you confirming for the parties, but you're also confirming for the jurors so that, you know, God forbid, later down the line, they're not like, no, I never said that, right? So it's important. It's important to have all that on record. And I feel like it shouldn't even be something that's asked or It should just be expected. It should always happen in every single trial, right? Because that's where you can have things like this happen, right? So, courts in this state and others also polled juries to determine whether deadlock exists or if future deliberation would be useful. A Massachusetts Guide to Evidence Section 606B and Rule of Criminal Procedure 27D both allow the court to poll juries after a verdict has been returned. Granted, it is within the trial judge's discretion whether to poll the jury, Commonwealth versus Hardy. And this is my whole argument, is like, this shouldn't even be up to the discretion, up to the trial judge. It should just happen, right? What's the harm in getting confirmation so we're all on the same page, right? It should just be a common practice. But there are times when a judge should use the discretion accorded to Massachusetts law to poll a jury after the verdict is returned, Commonwealth versus Zacharias. See also Audette versus Zackskin, or however you say that, Fishing Corp. For example, in Commonwealth versus Nettis, the trial court properly conducted a poll of the jury when one juror indicated her disapproval of the announced verdict. As with the evidentiary hearings discussed above, because remember, you have a foreman, he's collecting the votes, he's passing the notes off to Beverly Cajonas. And in this case, we know where the foreman stood. We know he was the guy who wrote the Juror Doe affidavit in fear for his life as he's citing Julie Carpenter, who, as I have recently come to find out, blocked me for whatever reason on Twitter, even though I've never interacted with her once. As with the evidentiary hearings discussed, the above the court's polling of juror votes does not impermissibly intrude into the jury's deliberative process, Commonwealth versus Spann. Federal trial courts have also polled juries to determine whether they are truly deadlocked ahead of a mistrial declaration in the United States versus Barbioni. The jury deliberated for 10 hours but could not reach a verdict. Before declaring a mistrial, the district court polled each juror individually and with great care. All stated that the jury was deadlocked and not likely to reach a verdict. It's like, what's the harm? What's the harm in just getting answers? If you really believe in truth and justice, wouldn't you just want the correct answer, right? Wouldn't you want to get to the bottom of this ASAP so you can save everybody tax dollars and time? On appeal, now if your name is Meatball, on appeal, the First Circuit found these actions supported manifest necessity for a retrial. Many other federal courts have also polled individual jurors to ask whether a deadlock exists before declaring a mistrial. And then we got some examples here, right? United States versus Jefferson, United States versus Wecht, United States versus Charlton, and Clark versus Irvin. State trial courts have likewise polled jurors ahead of mistrial declarations in order to determine whether manifest necessity exists. In State versus Gendreau, the jury sent 3 notes that indicated a potential deadlock. So very, very similar to the Karen Reed case, right? The trial court individually polled the jurors after each note to determine whether deadlock truly existed. That's very fascinating. On appeal, because Bev was more like, get back in there. Get back in there. I believe in you. Right? Like Coach Taylor, except with crabs. On appeal, the Maine Supreme Court characterized this effort as thorough and appropriate to determining whether a mistrial was manifestly necessary. Other state courts have exercised similar care to thoroughly assess whether a mistrial was necessary. People versus Halverson, Guerra versus State, Ex parte McNabb, Parker versus State. Overruled on other grounds. Interesting. Lysenring versus Castellino, This kind of pre-mistrial polling is not only permitted under Massachusetts law, but it's encouraged. Under Rule of Criminal Procedure 27B, a court intending to declare mistrial may ask that a jury return verdicts on those charges upon which the jury can agree. The reporter's note to Rule 27B states even more definitively that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree upon. Some courts, so this is a fancy footnote, have gone even further. For example, in Halverson, the jury was potentially deadlocked on the punishment for one count, very, very similar to this case. After asking the jurors whether additional deliberation would be useful, the trial court specifically asked where the jury was leaning numerically. California Supreme Court concluded that the judge's actions supported his later declaration of a mistrial. So again, somebody who's trying to get to the bottom of it so that this, excuse my language, crap doesn't happen. Because who wants to do all this? Nobody. Nobody wants to do any of this. Except, again, if your name is Meatball. Like, you're in it. You're in it to win it, I guess. May the last meatball stand, right? Thus, Massachusetts law expressly enables judges to poll juries ahead of a mistrial to determine whether a full or partial mistrial should be declared. That fact supports appellant's requested evidentiary hearing because being such a hearing would achieve the same goal as polling, i.e. for the court and the parties to receive an accurate assessment of the jurors' conclusions without probing the subjective mental processes of jurors, such as the reasons for their decisions. Again, we don't care why they voted what they did. We just want to know what their verdict was. That's it. That's it. Yes or no. Did you vote not guilty? What did you vote? If it's a yes or no question, or if it's a open-ended question, or what did you vote? Right? That's it. That's it. On this count. Cool. This count, cool. This count, boom, done. Have a nice life. Trial courts also routinely hold post-verdict evidentiary hearings to address irregularities in jury proceedings affecting constitutional rights. The propriety of appellant's requested post-verdict evidentiary hearing is also supported by Massachusetts precedent, which allows for post-verdict evidentiary hearings that inquire into irregularities with jury proceedings that affect constitutional rights, including double jeopardy. I lost that jeopardy. The most prominent example of such post-verdict hearings implicates the Sixth Amendment right to an impartial jury, see U.S. Constitution Amendment 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury. Trial courts may conduct a post-verdict evidentiary hearing where evidence suggests that intrinsic influence may have had an impact upon the jury's impartiality. Commonwealth versus Dixon, again, another case law that we've seen quite often. The refusal to do so can itself constitute a reversible error where the case is closed courts should exercise discretion in favor of conducting a judicial inquiry. Thus, trial courts regularly hold evidentiary hearings to determine whether extraneous influence had an impact on the jury's impartiality, so I guess meaning whether the media or outside influences came into play, right? Commonwealth versus Werner, Commonwealth versus Bright, and the refusal to hold a hearing to consider extraneous influence has frequently resulted in reversal on appeal. Commonwealth versus Gizidi, Commonwealth versus Filia, Commonwealth versus Morrison. Evidentiary hearings have also been held to determine whether a jury's verdict was unanimous, as required by Massachusetts Rule of Criminal Procedure 27A, and as relevant for purposes of the Double Jeopardy Clause, since a prior acquittal or conviction bars a retrial for the same offense. Commonwealth versus Brown, the jury foreman claimed the verdict was erroneous, and the trial court held an evidentiary hearing wherein the jury corrected its verdict. Read that one again, folks. The jury foreman claimed that the verdict was erroneous, and the trial court held an evidentiary hearing wherein the jury corrected its verdict, meaning that this dude, who is the beholden gatekeeper between the rest of the jurors and the, in this case, the Honorable Beverly Cojones, yada yada, could get it wrong. He could be slipping her one thing, and then they could be like, whoa, hold on. Hold the phone for a second, buddy boy. We didn't necessarily agree with that. That's not what we said. And that's why it's important. That's why I just think it's like this should just be standard procedure. It's just always get a jury polling, and then you avoid all these problems altogether. On appeal, this court found no impropriety in the trial court's actions. In Commonwealth versus Diaz, a juror told the trial court that she had not agreed with the verdict. The court interviewed the remaining deliberating jurors, the court officers, the clerk of the court, and any personnel who had knowledge about the rendition of the verdict in this case, before declining to disturb the verdict. In the wake of this investigation, this court affirmed the lower court's denial of the defendant's motion for a new trial. Additional cases from this and other jurisdictions affirm the ability of courts to conduct such proceedings and take corrective action regarding jury verdicts. Latino versus Crane Rental Company, Brown versus Gunter, Martin versus State. To be clear, such inquiries need not reach the content of the jurors' deliberations, which again, Marty Weinberg said numerous times throughout his oral argument, or the particular reasons for their decisions. See Commonwealth versus Moore, Commonwealth versus Fiddler. There is no obstacle to a trial court taking evidence as to the outcome of the jury's deliberations, given that reporting such information is fundamentally the purpose of the jury. See Hebert. See also Mash G. Evid. Through such an inquiry, the court can determine the jury's decision, which necessarily bears on whether the robust protections of the Double Jeopardy Clause will apply. Section 4. We only got a few more pages left, folks. The trial court should be compelled to conduct an evidentiary hearing, given reports from jurors that the jury agreed appellant was not guilty on counts 1 and 3, such that the court did not have the manifest necessity to declare a full mistrial. In this case, after receiving a third note from the jury indicating difficulty reaching a completely unanimous verdict, the trial court declared a mistrial on all counts and set the stage for a full retrial. But as appellant's brief cogently describes, her attorneys soon received multiple reports from jurors, in some cases via intermediaries, that the jury had unanimously agreed to acquit on counts 1 and 3. See blue brief. Juror A stated that the jury unanimously agreed to acquit appellant on counts 1 and 3. Juror B believed that every member of the jury, if asked, would confirm that the jury would agree to acquit appellant on counts 1 and 3. Juror D said that every one of us will agree and acknowledge that the jury found appellant not guilty of counts 1 and 3. And Juror E confirmed that the jury was unanimous on counts 1 and 3. The Commonwealth also received communications from individual jurors about the jury's agreement on the first and third counts. See blue brief. It is thus unsurprising that the trial court accepted the jurors' statements about this agreement as true and accurate. Given such overwhelming evidence, we think so. Thank you. Finally feeling validated, right? Of the jury's agreement on counts 1 and 3, a post-verdict evidentiary hearing must be ordered to determine whether the jury decided to acquit appellant on any counts. such that the trial court did not have manifest necessity to declare a full mistrial. Such a hearing is warranted to assure the sanctity of appellant's right to be free from double jeopardy, a fundamental right wide in scope that is deeply ingrained in our legal system. Green. In the area of manifest necessity and mistrial, this court enforces that fundamental right by requiring the careful consideration of alternatives to a mistrial. Taylor, again, we went through this extensively during those previous filings by Karen Reed's team. And the nationwide practice of polling juries before mistrials are declared, see Supra Part 2. Part D. The trial court could have avoided the instant controversy by polling jurors individually before declaring a mistrial. Unfortunately, it did not, nor does the record reflect that the parties were given an opportunity to request or express their views on whether polling was appropriate. Blue brief. In any event, after the court declared a mistrial on all counts, it promptly received reports that its declaration of a mistrial was premised on an apparent mistake or misunderstanding concerning the jurors' conclusions, i.e., that they were deadlocked on only one count and had actually agreed to acquit appellant on others. At that point, the court not only could have, but should have held an evidentiary hearing to determine, in fact, there was manifest necessity for a full mistrial. The court's refusal to do so is reversible error. An evidentiary hearing was and remains necessary because of a lack of manifest necessity would mean that retrial on counts 1 or 3 violates appellant's rights under the Double Jeopardy Clause. See Downham versus United States. Taylor. Because that clause protects against the burden of enduring multiple trials, not merely the possibility of conviction upon retrial, a violation of appellant's double jeopardy rights can be remedied after a second trial, whether or not she is ever convicted. Retrial subjects the defendant to embarrassment, expense, and ordeal, and dare I say, harassment! Harassment! And compels her to live in a continuing state of anxiety and insecurity. Which, I mean, I can't imagine. How can you not? This has been taking up, like, nearly what? How many years now? Almost 3 years of your freaking life? And you haven't even had a chance to, one, breathe, deal with what's going on medically in your life, and also the fact that, you know, it's destroying your parents, right? God bless them, right? It's destroyed your livelihood, let alone the fact that she hasn't even had a proper time to grieve the loss of her boyfriend, the man that she loves. Now, I will say, I posted this earlier. Melanie Little and the Glare did a really excellent analysis on Karen Reed's text exchange with Officer John O'Keefe yesterday during a live stream, so I highly recommend. I linked it in my community tab if you want to check it out. It's really good because it opens your eyes up to a little bit more in understanding their dynamic as a couple, and how, I think, what if anything, it just further proves that there was absolutely no motive for her to unalive him in that moment in time. The prohibition is not against being twice punished, but being against twice put in jeopardy. Put another way, if the trial court lacked manifest necessity for a mistrial on counts 1 and 3, the appellant's double jeopardy rights will be irredeemably violated, even if she is someday acquitted on those charges at a subsequent trial. Thus, a wait-and-see approach would potentially permit an irreversible violation of the Constitution, and an evidentiary hearing is necessary now. Now. We want it now. The trial court denied appellant's request for a hearing because it concluded that such a proceeding would impermissibly intrude into the substance of jury's deliberations. In justifying that ruling, the court said that a hearing would necessarily require the court to understand any supposed tension between the jury's notes to the court and their agreement to acquit the appellant on 2 counts. But that is not so. the trial court is well situated to set appropriate limits on any questioning, and it may only need to ask each juror whether the jury reached a unanimous verdict on count 1 or 2 or 3. That's it. It really could just boil down to one freaking question, Bev. That's it. That's all we were asking for. And then you can have as many White Claws as you want, as many crab legs as you desire. And now I'm hungry. Look what you did. Look what you made me do, Bev. As cases like Span make clear, questioning to confirm or understand what the jury decided does not intrude into the deliberative process. In response, the Commonwealth may claim that because post-trial reports from jurors A, B, D, and E, because we're going down the freaking alphabet here, were not in front of the trial court when it declared a mistrial, a partial verdict was not a reasonable alternative. I don't know why it said it like that, but I did. At the time of the court's declaration. But that argument fails for 2 reasons. First, as appellant observes, see blue brief, the jury's communications with the trial court are susceptible to the interpretation that the only deadlock was related to the lesser included offenses of count 2. And we've said this, screamed it from the frickin' rooftops 1,000,007 times. The frickin' verdict slip was confusing, Bev, and that's why Alan Jackson had a quote conniption about it, because it was confusing AF, and you were essentially guiding the jurors into making that decision. And I always go back to this. I posted this video a while ago because it was first, I think, shared by, shout out to Microdots, about the potential hot mic moment from Bev. So I don't know who would have been on that hot mic or not, but according to the hot mic moment, and I'll cue that video up if you want to check it out. It's like 10 minutes long or something. Somebody who could have been Bev, I don't know who it was. I don't know if this was ever found out, but I always think about it. Somebody on the hot mic said, I never changed it. And if you're talking about the verdict slip, then my God, that is a big fat freaking problem, don't you think? But I guess it wasn't her? I don't know, but nobody seems to talk about that anymore, and I would love to just have an answer with who was that? If not Bev. I don't know. So the trial court had reason to believe that a poll aimed to return a partial verdict was a meaningful alternative to a full mistrial, especially given the existence of Rule 27B. Second, cases like Diaz and Brown demonstrate that post-verdict evidence can support a post-verdict evidentiary hearing into the content of the jury's agreement, even if the evidence was not known to the court ex ante. See supra part tres. Thus, the fact that evidence suggesting the jury reached a partial verdict arrived after trial does not preclude an evidentiary hearing. The timing also supports the use of an evidentiary hearing, as memorialized in attorney affidavits. Jurors began raising concerns about the mistrial the day after that declaration was made. Yeah, they were all like, is somebody gonna tell Beverly that, no? Okay, cool. And others quickly followed suit. And they didn't just contact David Gannetti and Alan Jackson. They also contacted Lally, who responded whenever the heck he did, because it was very convoluted with the timeline that was written in his court filing. His response, right? Of, oh yeah, they actually did message me, but I told them that we wouldn't be able to protect their identities what if anything, we were going to continue to divulge into this and further investigate. Yes, I'm Lunchbox. So there's robust, uniform, and contemporaneous, what a word, evidence of what the jury agreed to. Supported by that evidence, appellant requested an evidentiary hearing within 1 week of the mistrial. Beyond that, the specific nature of this mistrial context lessens the risk of eternally influenced post hoc changes. It always reminds me every time I see Hawk, I always think of that Deadwood episode where they're holding like their first like town meeting.
Yeah, ad hoc.
Ad hoc. Good.
Ad fucking hoc.
So
Free
just
fucking
10
gratis.
yeah.
Can we just get on with the fucking meeting?
It's one of my favorite shows of all time, and I do have this distant dream of doing like a separate like rewatch channel where I just talk about Deadwood all the time because it is the greatest show of all time. Fight me in the comments about it because you know it's true. Anyways, I continue. Ad freaking hoc. This is not a situation where court be likely to find an agreement to acquit based on one juror's changing view or post-trial misgivings, both because a significant portion of the jury has already come forward to evidence their agreement, and also because all the jurors apparently remain available to testify. And it seems like a lot of them, 2 have already spoken to Turtle Boy, right? So maybe more will speak up and come forward, but they've been talking to the press, so it seems like it's still bothering them, and they want, especially the closer we get to this hearing as well as the retrial, if there is a retrial, I feel like more and more are going to start piping up, right? Almost 400 years ago, the Massachusetts colony enacted the first formal prohibitions against double jeopardy on American soil. In accordance with this tradition, the court should require an evidentiary hearing to ensure that appellant's double jeopardy rights are not violated by a second trial on counts for which the jury already agreed to acquit her and for which the trial court did not have manifest necessity to declare a mistrial. Such a remedy is necessary to maintain the double jeopardy clause as that bulwark, there's that buzzword again, of liberty, Cooper, which stands against the devastating and one-sided nature of jeopardy, and that confronts, I didn't want to actually slam because it's going to alarm my cat and my wife, that confronts criminal defendants facing retrial, Martin versus Commonwealth. Conclusion. For the foregoing reasons, this court should vacate the decision of the trial court denying appellant's motion to dismiss and remand for the trial court to conduct an evidentiary hearing if the charges are not otherwise disposed. Dated today, October 16th, which also happens to be, and here's a little certificate of compliance where they're saying, hey, this complies with the rules of appellate procedures. Cool. Hereby certify. Yep. So, there you have it, folks. ACLU now has entered the arena. And it's Team Karen Reed. So what are you going to tell me? Everybody, all of these powers that be, everybody, the ACLU is conspiring with her, Turtle Boy. All these people are conspiring with Karen Reed. The feds. Oh my God. Conspiracy. It's just getting ridiculous with a lot of these honestly conspiracy theories, right? It's absolutely asinine. But what say you? What do you think about the ACLU stepping into the ring? As Mark Betterow stated earlier, this is nothing for us to get too excited about, but nevertheless, it's still always exciting, and I think it's quite ironic considering the deadline for the Commonwealth is also today. So will they get something in at the absolute last hour? Who knows? It wouldn't be out of character for them. But with that being said, if you enjoyed today's video and you want to see more content like this from me, make sure you hit that subscribe button. Make sure you hit that notification bell so you do not miss the next Karen Reed update from me, because you know that every single day, especially now because we are in go time. This hearing is coming up on November 6th. So if you want to keep up to date with all the latest and greatest in regards to this case, make sure you hit that like button, because that tells the YouTube algorithm that this is newsworthy news. Yeah, it is. It is. Now the ACLU has entered the arena, and it just further shows that there's not just people in Norfolk County. It isn't this small, little, tiny case. Everybody's got eyes on this case. Everybody is watching, even the ACLU. And not for nothing, like I said, usually we don't see the ACLU stepping into the ring for cases involving what would seemingly be, let's call it for what it is, on paper, a privileged white woman. We just don't see that. So I think this is, yeah, okay. In the words of Mark Betterow, it's not too much of a big deal, but at the same time, it's just nice to see that Karen is still continuing to make headlines. Her case is still getting out there, still getting exposure, getting the word out to more and more people, because she needs our help more than ever. And if you want to make a donation to the Karen Reed Defense Fund, you can do so. I always link it in my description box below. So donate if you want to support, or if you don't, you don't. Just like this video and it'll get the message out to more and more people, and then we can continue to put more pressure and fight the meatballs. Not these meatballs, but this meatball. Let's take a stand against meatball together and just keep meatballs on our spaghetti.